The Creator gave 7 grandfathers, who were very powerful spirits, the responsibility to watch over the people. The 7 grandfathers gave the following gifts to the people to help guide them in their spiritual journey. To cherish knowledge is to know wisdom. To know love is to know peace. To honor all of creation is to have respect. Bravery is to face the foe with integrity. Honesty in facing a situation is to be brave. Humility is to know yourself as a sacred part of creation. Speak the truth. Do not deceive yourself or others.
Ani, Sego, Wache. Hello, I'm Linda Kitchagisik.
I'm Lawrence Martin, and we're here to guide you through the information program on family law for both on-reserve and off-reserve Aboriginal people.
When we separate from our partners, it is a very difficult time, even more so when children are involved. The end of a relationship can mean we have to deal with emotions, help the children make a positive adjustment, make legal decisions, develop parenting arrangements, deal with financial issues.
This program is intended to provide general information to everyone who is experiencing a relationship breakdown.
While it will provide you with options on how you may work with your former partner to resolve disputes, it is not meant to provide you with specific advice on your family situation.
The purpose of this information program is to help you understand the effects of ending a relationship on adults and children, help you understand the options available for dealing with the legal and emotional issues related to relationship breakdowns, help you make more informed decisions.
Together, we will cover 7 topics: awareness and feelings, navigating through the separation process, interacting with former partners, the legal issues, options to resolve disputes, courts in Ontario, moving forward.
The program presumes that those of you that are parents will work together to meet the needs of your children. However, in situations where domestic violence, abuse, mental health, or addictions are a factor, working with your former partner to resolve your family disputes may not be realistic or safe.
If you feel your safety is at risk, or that the safety of your children is at risk, the number 1 priority is to make sure that you and your children are safe. All adults have the responsibility to protect children, both from being victims of abuse and from witnessing ongoing violence.
Your safety or your children's safety may be at risk if your partner has ever physically abused you or your children, ever sexually abused you or your children, ever threatened to hurt you or your children in any way, ever made you feel that if you left or your partner left, you or your children would not be safe, ever threatened to take your children away, ever said or done anything else that has made you feel that you and your children are not safe.
As part of your safety planning, write down the telephone numbers of your local agencies that can offer help and support should an issue of your safety or the safety of your children arise during the separation process. Examples include your Friendship Centre, Aboriginal court worker, band social worker, band community base worker, police RCMP, women's shelter, Legal Aid Ontario, and the Assaulted Women's Helpline. You can speak with the Information and Referral Coordinator at your local court office for more information about the local resources in your area.
If your spouse is violent towards you or your children, you can ask a judge for a court order to help protect you. Ask a lawyer, an Aboriginal court worker, police officer, or information referral coordinator for information on how to get a court order, such as a restraining order.
A restraining order means your partner has to stay away from you and your children. This is an order made by a family judge in family court. If the person who has a restraining order against them disobeys it, the police can arrest them.
If your partner has been arrested for being violent towards you, a judge can make a no-contact order that directs your partner not to contact you or your children. The Ministry of the Attorney General has developed a self-help guide, How to Make an Application for a Restraining Order. The guide is available on the Family Justice page of the Ministry's website.
To face life with courage is to know bravery. Use personal strength to face difficulties, obstacles, and challenges. Have courage. Make positive choices. Stand up for your convictions. Show courage in communicating and decision-making.
This section explores the emotion we and our children go through when we separate. It is important to understand our emotions and those of our children in order to be able to support our children and ourselves. With separation, adults experience loss. We lose the person we were in a relationship with. We lose the hopes or dreams we had for the relationship. This sense of loss can affect our health in different ways.
Loss of identity, loss of sharing, social changes, changes in your parental role, and changes in social activities can affect your emotional health. Loss of your sexual partner, loss of friends and in-laws, changes in the family structure, physical changes, financial and economic changes, and changes in social activities can affect your physical health. Loss of hopes and expectations, loss of routine and structure, and handling legal changes can affect your mental health. When you lose the hopes and dreams for your relationship, your spiritual health can be affected. Everyone who separates from a partner experiences many different types of emotions. You may feel depressed, anxious, like it's hard to cope, angry, guilty, relieved, afraid, out of control, vulnerable. People who are separating say that they experience more than one emotion and that their emotions are unpredictable. You may feel happy and relieved in the morning, but angry and hurt in the afternoon. Most people say they feel shaky and vulnerable. Some feel alone and depressed. Remind yourself, these feelings are normal. They will not last forever. I will survive.
Sometimes parents may feel that they have failed their children and may doubt their own worth. These emotions and difficulties are often a natural part of getting through separation. Remember, feelings do not cause behavior. We have no choice about what we feel, but we do have a choice about how we act on those feelings. We can choose to respond in ways that help the children make a positive adjustment. How we handle our own feelings and how we relate to the other parent will affect how well our children adjust to the separation. There are 7 stages people go through as they heal from loss and grief. Your individual healing process may flow differently than this outline, but usually it goes something like this.
First, I feel shock. I feel numb and afraid. My brain is shutting down feelings to help me cope.
The second stage is denial. I do not admit that there is pain and perhaps painful memories. I am denying the hurt or pain.
The third stage is anger. Why did this happen to me? I'm outwardly angry because of my situation.
The fourth stage is blaming. Why did she hurt me? I blame my former partner for the separation and present situation.
The fifth stage is transition. I wonder what went wrong. I'm still sad and maybe depressed, but I'm beginning to reach out to others.
The sixth stage is acceptance. I accept that I can grow from my hurt. I am moving forward in a new life and maybe working towards a good parenting partnership with my former partner.
The final stage is healing. I feel good about myself. I know I can make it. I notice a good feeling about myself and my ability to grow and change.
Balance is once again achievable. Like adults, children experience stages of loss and grief, denial and isolation, anger, blaming, bargaining, depression, acceptance, healing. As with adults, children may not go through these stages in order, and the time this process takes will vary from child to child. If only one parent is involved in the child's life after separation, children often believe that the other parent is not interested in them because they are not good, important, or worthy of attention and love. Children often experience anger, sadness, rejection, and guilt. All of these emotions are confusing. They may also feel relieved, which they then feel guilty about.
During a separation, children want to know, Mom and Dad will continue to love me. Mom and Dad will stop fighting. Both Mom and Dad will be here in my life. If I can't have that, at least one of my parents will be here in my life.
Children of different ages have different responses to their parents' separation. A lot of this may sound familiar to those of us with parents who separated when we were kids. In general, when parents separate, preschoolers focus on security. They wonder, who will take care of me? Elementary school children show depression and/or anger. Junior high school students ask, why? What is going on? High school students question whether long-term commitment exists in relationships.
To honor all creation is to have respect. Show regard for the value of all persons or things through courteous consideration and appreciation. Honor our traditional roles and teachings. Honor our families, others, and ourselves. Don't hurt anything or anyone on the outside or the inside. To accept yourself as a sacred part of creation is to know humility. Reflect on how you present yourself. Express or offer in spirit of deference and submission. Use a balance of equality with all life. Recognize the human need for balance in life.
Now that we have a better understanding of the emotions that we and our children are experiencing, we can begin to see what we must do for the emotional, physical, mental, and spiritual health of ourselves and our children. This understanding will help us to nurture our relationships with our children, our family, and our friends. It will also allow us to repair those relationships that may have been damaged by the separation as we progress through our healing journey.
We have no choice about what we feel, but we do have a choice about how we act on those feelings. We can choose to respond in ways that help the children make a positive adjustment. How we handle our own feelings and how we relate to the other parent will affect how well our children adjust to the separation.
In a small community, a separation of parents can affect many people besides the children and the individuals who are separating. The layers of community that can support and assist children and individuals in their time of need and in the healing can best be described as follows. Closest to the children are the parents who are separating, followed by immediate family, extended family, traditional house, elders in the community, community members, and the whole nation.
Going through a separation can be extremely stressful for you and your family, and you should first take care of yourself both physically and emotionally before you can take care of anything else.
It is important to express sadness over the loss of your partner, as well as the end of your hopes and dreams for the relationship. Not mourning a loss can result in you not letting go of your interest in your former partner's life. You have every right to dedicate time for crying, reflecting on your life, or simply being alone.
Separation may bring on feelings of anger and resentment that can affect you for years. Emotional flashbacks or bitter feelings can be stirred up when you see your former partner or hear about what he or she is doing. It is important to resolve your anger and resentment in a healthy way in order to move on.
You must reclaim yourself by separating from the relationship and establishing a new sense of self-identity. It is a move from we to I. Try to view this time as a chance to start over. Remember the strengths you had before the relationship. Think about what you've always been good at and what brings you joy and happiness in life. It also helps to reach out to trusted friends and family members. You may wish to take advantage of counseling from elders and other counselors to help you sort out your feelings.
Although separation can very easily throw your daily routine into a chaotic mess, try to avoid this as much as possible. A familiar routine and stability provide comfort, and the more you can keep to your day-to-day schedule, the easier it will be to cope.
For your mental health, keep yourself busy socially and intellectually. Having an active lifestyle can also take your mind off the stress you may be experiencing.
Just as your mental wellness is essential to managing stress, so is your physical health. Be sure to eat a balanced diet, exercise regularly to stay fit, and work off stress in a productive way.
Don't rush into decisions. Take all the time you need to think about making any major life-altering steps, such as changing careers or starting a new relationship. If you make important decisions when you're under a lot of stress, you may regret them later.
Try to be positive. In some ways, the end of your relationship may seem like a failure, but you shouldn't look on it that way. Try to think of the new possibilities your separation opens up that were not available to you before.
It is likely that your finances will change upon separation. You may have short-term problems dealing with a drop in income. You'll need a different short-term and long-term financial plan. If necessary, get some advice. If you live on a reserve, speak to your band council or with family members who should be able to help you in changes to your housing situation. If you live in a more urban center, you may wish to visit a friendship center or speak with an information referral coordinator at the court office who can direct you to housing agencies in your community.
When the timing feels right to you, make plans for your future. Set up goals for yourself and develop a plan of how you can achieve them.
There may be changes in the way you relate to friends you had as a couple, and to your extended family and your ex-partner's extended family. You need to deal with these relationships in a healthy way.
Finally is the task of rebuilding. The goal is to create a new healthy relationship or to have a satisfying life as a single person.
As we well know, separation is hard on children, too.
If you have not yet separated, here are some suggestions on what and when to tell your children about your breakup. Tell the children about the separation only when you have made clear plans about what will be happening to them. Tell your children with both parents together if you can. Pick a time and place where there will be no distractions or interruptions. It may help to tell all your children at the same time rather than separately, so they can provide support to one another. Discuss your future living arrangements. Tell them they will be loved in 2 homes now, if that is going to be the arrangement. Talk about their particular needs, such as friends, toys, and school. Allow your children to show grief and sadness and invite them to talk it out, draw it out, write it out, or cry it out.
Telling the children may be the most painful part of the entire separation process. Here are some statements you may find useful. If you have concerns about safety, some of these statements may not work.
You did not cause the separation or divorce. We are not going to ask you to take sides. You will continue to be loved, taken care of, and provided for.
If you have already broken the news in a different way, try not to beat yourself up about it. You can't change the things you've already said. All you can do now is move forward and try again with these new ideas, such as,
When we got together, we loved each other and believed things would work out. It was not an easy decision. After a lot of effort to save the relationship, we decided we could no longer live together. While our feelings for each other have changed, the special relationship between us and you, our children, goes on forever. Relationships with us, with your brothers and sisters, with your grandparents, aunties and uncles, and other relatives will continue. Some things about these relationships might change though.
here's what they don't need to hear.
It's the other parent's fault. One parent is the good guy and one the bad guy, even if you feel that way. They don't need to hear the details of what went wrong. Children don't need information about personality problems, money problems, or affairs. This information burdens children. They definitely don't need to hear negative statements about the other parent. Saying negative things about the other parent puts children in emotional conflict.
Sometimes parents play games that put children in the middle of their battles. The children can be hurt by these games, which are often a result of feelings of anger and hurt about the ending of the relationship. It is important to deal with these emotions and to change to a new, formal way of communicating with the other parent.
Here are some common games parents play. Threatening to get what you want.
If you don't pay child support on time, I won't let you see the kids.
When you behave in this manner, you are focusing on your relationship with your former partner. You must focus on your child's needs, not your feelings. Telling the children to take messages to the other parent.
Tell your father to get the support payments to me on time.
Being a messenger is a painful burden for children. Parents must communicate directly with each other. Interfering with the time the other parent has to spend with the child. For example,
Dad telephones his son and tells him that he has tickets to a game, but it's not happening on the weekend of their regular visit. Dad tells the son to ask his mother. Mom, in turn, says no. The child is then angry with Mom for not allowing the treat.
trying to get information about the other parent. Who is your father seeing? Who does your mother have over to the house?
Children do not like being used, being asked to break the trust of a parent, or bearing the anger of a parent who is upset with the information.
Another game is I Wish, where you talk about your dreams, about what things would be like if the family were back together. A child might tell a parent how nice it would be to be back together. The parent agrees that it would be good.
Doing this may give the child false hopes of getting his parents back together.
Buying expensive gifts or taking the kids on expensive outings. Often the parent who buys the gifts cannot afford to, but feels it's the only way to connect with the kids. Children may come to expect special gifts, treats, and rights on an ongoing basis. They may not develop a realistic relationship with the parent or a realistic view of family life.
Criticizing the child's visit with the other parent. For example, the child has just returned from a trip to the zoo. The other parent criticizes everything they did. The child ends up feeling bad about the day.
Putting down the other parent in front of the children. Parents may do this for two reasons. Either they feel that this is the only way they can win a child's affection, or they are relieving built-up anger. Either way, this only hurts the child.
Because children experience themselves as made up of both of their parents, they feel an angry remark as an attack on part of themselves. A put-down directed at the other parent affects the child as well, causing pain and lowered self-esteem. There are a few more things you can do to make things easier for your children. First, keep a structured and regular routine, similar to what existed before. Stick to a daily routine with your child. Make changes slowly and talk about them. Encourage your child to play with friends and have a normal life. Try to keep your child's environment as stable as possible. It is not a good idea to make too many changes at one time. For example, your child may be getting used to having only one parent at home every night. Moving into a new home or going to a new school may be too much for her at the same time.
Maintain rituals around birthdays, holidays, etc. This helps provide a sense of security and helps your children plan and look forward to family events.
Help children feel free to ask questions. Tell them about the changes well ahead of time. Children want to know what is going on in their lives.
In their grief, children may express feelings of anger towards you. Try not to take them personally. Your child is trying to make sense of the separation. When your child is upset, you could try to use mirroring.
Mirroring is simply stating back what your child has just said. For example, "I hate you, Mommy. You made Daddy leave." You can mirror this back by saying, "Right now you feel like you hate me because you think I made Daddy leave." Mirroring can help a child to feel understood.
Tell your children you love them, and it was not their fault. Your children need your support now more than ever. Children need to hear over and over that you love them no matter what happens. Explain to them that while the love adults have for one another can change, the love a parent has for a child can never change. Tell your child that the separation was not his fault, that it's okay to feel sad about the changes. Avoid making your children take sides. Some children may feel guilty for having a good time with the other parent.
Children need limits, so it's important to set limits on their behavior. They need a stable home life with clear rules and a parent they can depend on to be consistent about the limits. Sometimes they test these limits. However, in maintaining limits, you are helping them feel secure. Children have chores appropriate to their ages and abilities are better able to adjust to change.
To walk through life with integrity is to know honesty. Be truthful and trustworthy. Tell the truth. Accept and act on truths through straightforward and appropriate communication. To cherish knowledge is to know wisdom. Use sound judgment and the ability to discern inner qualities and relationships. Use good sense and form a good attitude and course of action. Listen and use the wisdom of elders and spiritual leaders. Respect means listening until everyone has been heard and understood. Only then is there a possibility of balance and harmony.
How to approach our former partner on matters relating to parenting our children after we have separated is not always straightforward. It is important to understand that sometimes we will not agree, and it may be necessary to involve someone from the community to help us resolve our disputes, and in some instances, we may need to involve the court.
The following information may provide you with ideas and options when dealing with your former partner on post-separation matters, including matters involving your children. Remember that none of this applies if you have any concerns about your safety or if you are dealing with someone who is abusive.
Accept the idea that you will be parents forever. The family is not ending, it's being reorganized. Recognize that you still share love and mutual concern for your children. This is the new basis of your relationship. Separate the children's needs and concerns from your own. Your child does not experience your former partner in the same way you do. Create new limits in the relationship with your former partner. Do not use old patterns, create new ones. Behave towards your former partner as your business partner in raising the children, not your mate. Focus on the strengths in your relationship, what you have done well together as parents, and build on those strengths. Also, keep in mind that depending upon the type of relationship you have with your former partner, some methods of communication may work best for you. For example, in person, on the phone, email, text messaging, fax, or mail.
Keep talk brief and centered on child-related issues. Be clear and specific about what the problem is. Never communicate through your child. Be courteous and respectful and act like a guest when you are in the other parent's home. Don't expect appreciation or praise from the other parent. Avoid blaming yourself or your ex-partner for what happened in the past. Don't discuss relationship issues. Don't fuel each other's anger. Remain calm and don't react. Have possible solutions ready. Don't respond to abusive emails.
It is important to understand the legal issues when separating from your former partner. This will help in deciding what to do next. If you are married, the only way to legally end your marriage is to get a divorce. You must start a court case to get a divorce, but if you and your former spouse agree about what each of you want, you may not need to appear before a judge. In many cases, parties can simply file an affidavit that is reviewed by a judge in his or her office. You cannot marry again until your divorce is final.
There are 3 ways to demonstrate to the court that your marriage has broken down. You and your spouse have been living separate and apart for at least 1 year before you apply for a divorce. Your spouse has committed adultery. Your spouse has been so physically or mentally cruel to you that you can no longer live together.
The matrimonial home is where your family lives. Often, it is the most valuable asset your family owns.
There are different rules on how the matrimonial home is treated depending upon whether it is located on or off reserved lands.
First Nations communities manage their reserve lands under the Indian Act, the First Nations Land Management Act, or a self-government agreement.
Under the Indian Act, a band does not own reserve land but has the right to use it. Bands have different systems for assigning land and housing, including certificate of possession, land used by a person or family members through tradition or custom. Ontario courts do not have the authority to deal with matrimonial homes located on reserved lands. For example, the court cannot order the spouse with a certificate of possession to leave the matrimonial home so that the other spouse can live there, nor can the court make decisions on the division of the matrimonial home.
Even if both you and your spouse are named on the certificate of possession, a judge has no authority to decide which spouse can stay. This means that the spouse with custody of the children may have to leave the reserve with the children if no alternative housing is available.
The court can, however, order one spouse to pay money to the other in the amount that represents the spouse's share of the value of the matrimonial home.
Where the matrimonial home is located off reserve, both spouses have the right to occupy it. It does not matter if one person owned the home before you married. If you cannot agree on who will stay and who will leave, you may have to ask a court to make an order for exclusive possession. The court may also order the sale of the home and give directions on how the money will be divided between you.
The law also provides that the value of the matrimonial home, regardless of whether it was owned by one spouse prior to marriage, must be divided equally between the spouses. The same law applies to same-sex and opposite-sex married couples, but it does not apply to couples who were never married. There is no legislative requirement that property be divided for unmarried couples. Generally, couples who live together do not have the same rights as married couples to a share in the value of property, including, in some cases, the home they live in, unless the property is in both of their names or they paid for it together. If you are not married and are considering making a property claim, you should seek the advice of a lawyer who has experience with family law.
According to Ontario's Family Law Act, marriage is an equal partnership. When a marriage ends, the partnership is over and property has to be divided. The equal contribution of each person to the marriage is recognized. The law provides that the value of any kind of property that was acquired by a spouse during the marriage and still exists at separation must be divided equally between the spouses, including the matrimonial home you shared. Also, any increase in the value of property owned by a spouse since the date of marriage must be shared. This is accomplished through an equalization payment or an equalization of net family property.
Sometimes the Indian Act may be used to protect the property interests of an Indian child living on a reserve. The minister can administer or provide for the administration of entitled property of an Indian's infant child, or may appoint a guardian for this purpose.
Some married couples may have a marriage contract or a prenuptial agreement. If you have one of those agreements, you should refer to it because it may include a different approach to property division or support.
Unlike married couples, there is no legislative requirement that property be divided for unmarried couples. Usually, houses, furniture, household belongings, and other property belong to the other person who bought them. However, if you have contributed financially or otherwise to property your partner owns, you may be able to claim a share in it. If you are not married and are considering making a property claim, you should seek the advice of a lawyer who has experience with family law.
Decisions about children must always be made in the best interest of the child. When you separate, you will need to make some very important decisions, such as: who will your children live with? What role will the extended family have after separation? How much child support should be paid? What school will your child attend? How will your child be raised spiritually? The doctor your child will see. When will your children see the parent or the family members they do not live with? It is in the best interest of your child to have a close, stable, and ongoing relationship with both parents whenever possible.
Sometimes this is not possible, especially in cases where there is violence or abuse against a parent or child. If it is possible for both parents to maintain a close relationship with your child will benefit greatly from having both your support to deal with the separation, having help to become emotionally healthy, a sense of relief from feeling divided loyalties, having help to lessen any guilt that he or she may feel, continuity in parental authority, having parents who are willing to provide support, being able to continue relationships with his or her extended family, seeing that the parents can unite around parenting despite their personal differences.
A parenting plan is a document that explains the decisions you've made about caring for the children. For example, it describes how each parent will spend time with the children, how you will share information with the other parent, how you will make decisions about the children, how you will deal with other parenting issues.
When you are deciding what parenting arrangements are in the child's best interest, you have several options. You and your partner can reach an agreement on your own. You and your partner can get help to agree by using a neutral third party such as a mediator. You and your partner can negotiate an agreement using your own lawyers, or you can go to court and ask a judge to make a decision. A parenting plan can be an informal arrangement between the two of you, or it can be part of your separation agreement or court order. If the arrangements are informal, they can be difficult to enforce.
It is always in your child's best interest to work together if possible. But if you and the other parent cannot agree, or if there is abuse in the relationship, it is best to allow a judge to decide.
Aboriginal parents living on a reserve are subject to provincial laws, provided these laws do not conflict with the Indian Act. A Métis or non-status Indian person comes under the provincial family law. All of these laws about parenting focus on what is in the best interest of the child. So for the most part, these laws apply to an Aboriginal person regardless of their status.
Where parents are separating from one another and are unable to agree on the plans for the children, the law says the judge must consider the following when making a decision in a child's best interests: the love, affection, and emotional ties between the child and each person who is entitled to or is making a claim for custody or access, other members of the child's family who live with the child, and the people involved in the child's care and upbringing.
The child's views and preferences, if they can be determined.
The length of time the child has lived in a stable home environment.
The ability and willingness of anyone presenting a plan to provide guidance and education, provide the essential things the child needs, and take care of any special needs the child may have.
Any plans that are proposed for the child.
The permanence and stability of the family the child will live with.
The ability of each person applying for custody or access to act as a parent.
The relationship between the child and each person who is asking for custody or access through blood or adoption.
In assessing a person's ability to care for the child, the court must consider whether the person has been violent or abusive to any child or their partner. When parents live together, both parents have custody of the child. Having custody of a child allows a parent to make the major decisions for the child, such as the child's education, religion, and medical treatment, and managing the child's property. Sometimes children can be in the custody of someone who is not their parent, like an aunt or a grandparent.
When parents separate, there are 4 possible custody arrangements. Sole custody means one person has the responsibility and authority to make major decisions about a child's care and how they will be raised. Usually, but not always, The child lives primarily with the person with sole custody. Joint custody means two people, usually the parents, share the responsibility for making decisions for a child. It does not necessarily mean that a child will spend equal time with both parents. Shared custody means both parents share the responsibility for making decisions and caring for the child. Under the child support guidelines, shared custody is where a child lives at least 40% of the time with each parent. Split custody is when parents have more than one child together and each parent has one or more children living primarily with him or her. A judge may make any of these arrangements into a court order. In some instances, interim or temporary orders are made, especially if things are in a state of flux or change. If there is a change in circumstances, you can apply to the court to have your order changed.
Access refers to the children's right to spend time with or access the parent that they do not live with. Other adults who the child does not live with can also have access. For example, a grandparent can have access. An agreement or court order can spell out exactly the access days and times that the visiting person can see the children. Agreements that spell out the exact access arrangements allow children to know what to expect and parents to know what is expected of them. This reduces the potential for conflict.
When abuse or violence is involved, the court may order access to be supervised. With supervised access, a parent is not left alone with their children. Instead, they have another person present to make sure the children are safe at all times. When the child may not be safe in a parent's care, the court may order no access.
If you go to court, you will give evidence about what your child's needs are and what parenting arrangements will work for your family. Gather all the information that may be relevant, such as the child's report cards, medical reports, letters from child care providers and coaches, photographs of your children together with your extended family, etc. If there is a power imbalance or abuse in the relationship, you may need special assistance when you are deciding what parenting arrangements are in the child's best interest.
In some cases, one or both of the parties raise concerns about the other person's ability to care for their children. These cases sometimes involve mental health or addiction issues and the input of a mental health professional, such as a social worker, psychologist, or psychiatrist, may be necessary. In those cases, the parties can agree or the court can order that the family undergo a custody and access assessment. The assessor is a neutral party with no ties or connections to anyone in the family. He or she will speak to each parent, to the children, and to any other people who may have relevant information, such as family members, the child's teachers, doctors, or other professionals who are involved with the family. The assessor will write a report to the court describing the needs of the children, as well as the ability and willingness of each parent to meet those needs. The report may include recommendations about how the children should spend time with each parent, how decisions should be made, whether a parent can move away with the children, etc.
Although the assessor does not actually make the decision about custody and access, the judge will give serious consideration to the assessment report when he or she makes the decision about these issues. The cost of an assessment is usually shared between the parents and can be very expensive. Another option for some families is to have an assessment done by the Office of the Children's Lawyer.
The Office of the Children's Lawyer can appoint a clinical investigator, usually a social worker, to conduct an assessment. There is no fee for the services of the children's lawyer. The Office of the Children's Lawyer becomes involved in a case at the request of the court. Parents may ask a judge for an order requesting that the Office of the Children's Lawyer become involved, and sometimes the judge will suggest that a referral be made. The office of the children's lawyer will decide whether or not they will become involved in the case and what type of assistance they will provide.
Access is not tied to child support. The law does not make a link between the child's right to see both parents and the paying parent's responsibility to make regular child support payments. When parents separate, each parent has the legal duty to financially support the child. Usually, the parent who does not live with the child pays support to the other parent to assist with some of the child's financial needs. The child involved can be a biological child, an adopted child, a stepchild, or a child for whom an adult has acted as a parent. Children of unmarried parents have the same rights to support from their parents as the children of married couples.
Family court judges use child support guidelines when deciding how much child support must be paid. These guidelines are legal rules that determine the appropriate amount of child support. They consider the income of the paying parent and the number of children support will be paid for.
The child support guidelines are designed so that when you separate, children continue to be supported by both parents after separation. They make it easier for parents to calculate an amount for child support. The guidelines can also reduce conflict and tension between parents by having rules determine child support.
In some cases, the court can award more than the guideline amount where the child has special expenses. These might include childcare expenses, tuition for private school, fees and equipment for hockey, or the cost of getting braces.
In very limited circumstances, the court can also award less than the guideline amount where paying this amount would cause undue hardship. In these cases, the parent asking for the decrease must prove hardship and that the standard of living in his or her household is lower than the standard in the child's household.
The Indian Act also makes some provision for the support of dependents. For example, the minister may make an order that an Indian person's annuity or interest money be paid to the spouse or family. To find out more information about child support and the child support guidelines, visit the Family Justice page of the Ministry of the Attorney General's website.
When a relationship breaks down, the law views the couple as an economic partnership for the purposes of determining whether spousal support should be paid. During a relationship, one person often spends more time looking after the home and the children. That person does not have a chance to earn a lot of money in the workforce, or to become more skilled and more highly paid in a trade or profession, or to pay into a pension plan over a long period of time. When a relationship ends, that person is at an economic disadvantage and may require financial support.
The law expects adults to be self-sufficient and to look after their own needs to the best of their abilities. However, it also recognizes that a person may need continuing support from their former partner to become self-sufficient to keep from ending up in serious financial difficulty. To decide on the amount of support that should be paid by one spouse to the other, the law says that judges must look at how much the person asking for support needs to live and how much the other person can pay.
In general, people who have been together for a short time will only be able to get support on a short-term basis. Support payments may give a person a chance to go back to school or train for a job. People who have been in a relationship for many years and out of the workforce or in low-paying jobs may never be able to become financially self-sufficient. Their spouse may have to pay long-term support for them. Here are some of the things that are taken into account. The age and health of the couple. Available employment opportunities. The effect being in the relationship had on employment opportunities. The contribution made to family care during the relationship. the contribution made to the other person's career, the family's standard of living before separation, the time it will take for the person to become self-sufficient, and the need to stay at home to take care of young children or adult children with a disability.
The Federal Advisory Spousal Support Guidelines are available to help you figure out the amount of support that should be paid. They provide a range of suggested spousal support amounts based on your circumstances and reflect amounts awarded by judges in similar cases. They are not mandatory, but were designed to assist you in reaching agreements about e-support. These guidelines apply only to couples who have been married.
Common law partners have a right to ask for support if they have lived together for more than 3 years, or they live together for less than 3 years, but have had or adopted a child together. Provision is also made under the Indian Act for the support of dependents, including the ability of the minister to make an order that an Indian person's annuity or interest money be paid to the spouse or family. To find out more information about the Federal Spousal Support Guidelines, visit the Family Justice page of the Ministry of the Attorney General's website.
All support court orders made in Ontario are automatically filed with the Family Responsibility Office, or FRO. FRO processes child and spousal support payments to help ensure that the support gets paid on a regular basis and takes action to enforce support orders that are not being paid on time or in full. When a court orders a person to make regular support payments, the court also makes a support deduction order. The court sends the support deduction order to FRO for enforcement.
If your support arrangements are set out in a domestic contract, such as a marriage contract, separation agreement, cohabitation agreement, or a paternity agreement, you can still have your support payments processed through FRO. But first, you must file your domestic contract with the court according to the procedure in the Family Law Act and the rules of court. Once the domestic contract is filed with the court, it can then be filed with FRO, and FRO can collect your support payments for you.
The Indian Act limits a provincial government's ability to pass laws that affect property or income held by status Indians living on reserve. This means that FRO's ability to enforce support orders is affected by whether the support payer and the support recipient are status or non-status Indians.
The Indian Act protects property and income held on reserve unless the person entitled to support is also a status Indian.
If the support payer and the support recipient or children are status Indians, the Indian Act does not limit the enforcement actions available to FRO.
If the payer falls behind in support payments and does not enter into a repayment plan, he or she is subject to all enforcement actions, which could include garnishing bank accounts, reporting the payer to the credit bureau, and seizing lottery winnings.
If the support recipient or children are not status Indians, FRO cannot take enforcement action against any of the payer's property or income held on reserve. However, FRO can take other enforcement actions, including issuing a support deduction notice for off-reserve income, placing a lien on or issuing a writ of seizure and sale for off-reserve property, suspending the payer's driver's license, and ordering the payer to attend court for a default hearing, which could result in up to 180 days of jail time.
With the exception of circumstances where the recipient or children are not status Indians, and if your support order or domestic contract is registered with FRO, FRO can act on your behalf to recover the money that is owed to you. FRO can request a default hearing at which the payer must explain to a judge why the support is not being paid, If the judge is not satisfied with the explanation, the judge can order that the support be paid. In extreme circumstances, the judge can send the payer to jail for failing to pay support, garnish the payer's wages, and bring the payer's employer to court if the employer disobeys or ignores the notice of garnishment, garnish the payer's bank account, seize the payer's RRSP, register the support order as a charge on the payer's house, other real estate, or personal property, file a writ against the payer's property, request records containing information about the payer's employment and financial circumstances and address from any person or public body, bring the payer's employer to court for disobeying or ignoring a support deduction order, deduct money owed to the payer by the federal government, including income tax refunds and employment insurance benefits, report the amount of support owed by the payer to a credit bureau, intercept the payer's lottery winnings if the prize is over $1,000 and the lottery was in Ontario, suspend the payer's driver's license, or suspend the payer's federal licenses or privileges, such as a pilot's license or a Canadian passport. For more information on FRO, you may find it helpful to refer to the Family Responsibility Office website.
Sometimes it is not possible for parents to resolve disagreements by themselves. When this happens, it may be necessary to involve a third party to help come to a resolution. Of course, you can go to court to resolve disputes, but let's look at the differences between making an agreement and going to court. Making an agreement between yourselves is not very expensive. It usually takes less time. It is a cooperative process. You decide your own agreement. The emphasis is on win-win. An agreement you reach yourselves helps to narrow personal differences. Going to court may be expensive, usually takes more time, is competitive, the judge decides there is a win-lose emphasis, and it widens personal differences.
Before we explore options for resolving disputes that involve third parties, let's talk about situations in which you and your partner agree. If you and your partner can talk openly and agree about plans for the child, and there is no safety issue involved, you can develop a parenting plan together. Consider putting your agreement in writing after getting legal advice. Remember, if you feel threatened by the other parent, do not negotiate on your own. Consult a family justice counselor, an Aboriginal court worker, your band social worker, your family support worker, a counselor, or an elder.
Here are some guidelines for negotiation. Before you get together, gather all your information and facts.
Choose a neutral place and a time when you can talk without interruption.
Decide together on rules for how you will talk respectfully to each other. For example, you may both agree you are going to stop the meeting if either of you starts raising your voice, interrupting, or blaming the other for the separation.
Speak clearly about what child-related issues you want to discuss. Stay focused on the topic. Don't bring up past faults and problems.
Ask the other person for their point of view. Listen carefully to what the other person has to say. If you don't understand, ask for more information.
Look at solutions together and give your solutions as suggestions rather than demands.
Make sure both of you agree on the solution. Specify who will do what, when, and where. For example, if the agreement is about when the other parent will spend time with the children, you should have a written plan about how and where the transfer will take place and what time the children will go and return.
Plan to meet again to review how the agreement is working.
At the end of the meeting, give positive comments such as, "I feel better about this, and I'm glad we were able to work it out together."
Legally, it's not necessary to have a separation agreement or a court order. But by writing it down, everything is clear and there is less chance for confusion or problems later. A written agreement is a contract between you and your partner that says what you have both agreed to.
A written agreement can also include all your decisions about custody and access and about child support. It can also include your decisions about how you are going to divide the things you own and whether one parent is going to contribute to the financial support of the other. Remember that when you are discussing child support, you should follow the child support guidelines. All decisions relating to children must be in the child's best interest.
Make sure both you and your partner sign the agreement. It's also a good idea to see a lawyer before you sign an agreement to make sure that you have protected your rights. Your partner and you should see different lawyers, so don't go to the same lawyer.
If it is a feasible option for you, you may wish to file the agreement with the court. If there are problems later, you can show a judge what you and your partner agreed to. Judges take these agreements very seriously, especially if you both had legal advice. You can also make your agreement into a consent order, which is a formal order a judge makes in court to affirm the agreement before signing the agreement.
There may be a community-based dispute resolution option available in your community that can assist you and your former partner to resolve the family issues that you cannot resolve on your own. You may wish to speak with the elders in your community or the band office to determine what might be available for your family.
Another option is collaborative family law. This type of alternative resolution differs from negotiations, where lawyers represent each person and conduct the negotiation. In collaborative family law, you and your former partner negotiate with the assistance of your lawyer. Court is not an option for lawyers who participate in collaborative family law negotiations. If negotiations break down and you or your former partner decide to go to court, neither of the lawyers or their law firms can represent you or your former partner in court. To find out more about collaborative family law or to find a collaborative family law lawyer, visit the Ontario Collaborative Family Law Federation website.
So far, we've talked about two options where you negotiate with your former partner. A third option involves a mediator who helps you and your former partner to reach an agreement. Mediation is not appropriate when one person does not want to participate, one person does not feel safe with the other person, the relationship is or was abusive, your child is at risk of being seriously harmed.
A mediator is an impartial person who can help you and your former partner develop a plan to deal with the legal issues around separating. A family mediator sits with you and your partner and helps you discuss the issues and work through your problems to reach an agreement. You and your former partner make all the decisions. The sessions can be confidential, or you can choose open mediation, and the mediator can be asked to report the outcome to the court.
Before mediation begins, the parties will be required to go through a screening process. The mediator will speak with each of the parties separately in order to make sure mediation is appropriate in all of the circumstances and whether additional safeguards are necessary.
When you're choosing a mediator, it is important to find someone you feel comfortable with. You need to feel you are being heard and that your input is being taken very seriously. You need to ask about the person's qualification and experience, including his or her experience in dealing with Aboriginal families and their issues.
If you don't feel comfortable, try another mediator. You may use mediation or separate meetings even if you are going to court. People often use mediation or separate meetings while they are proceeding with their court case. When something is discussed in mediation, you can obtain independent legal advice at the same time. If both of you can manage to agree, you can avoid a trial.
One important thing to remember in mediation is get independent legal advice about the issues being mediated.
Mediation is not the same as legal advice, and ideally, you will get legal advice both before the mediation begins and as the issues are being resolved through mediation. Usually, the mediator will record the outcome of the mediation in a memorandum of understanding, but this is not a legally binding document until it is made into a separation agreement or court order.
Visit the Family Justice page of the Ministry of the Attorney General website for information about mediation services available in the court nearest you. For more information on alternative dispute resolutions, you may also wish to visit the ADRO Institute of Ontario for help in finding a qualified family mediator in your area.
Like mediation, arbitration is a voluntary process, but it is more formal and is similar to the court process.
Both you and your former partner must agree to participate. The parties are responsible for the fees for the arbitration. The end result of a successful arbitration is an arbitral award dealing with the issues you have asked the arbitrator to decide on.
Arbitration is faster than the court process and allows the participants to choose the arbitrator to suit their case.
Before arbitration may take place, both you and your former partner must be screened separately for domestic violence and power imbalances. A report from the person who does the screening must be submitted to the arbitrator before the arbitration can begin.
Independent legal advice is mandatory for family arbitrations, which means you have to consult a lawyer. Any award from arbitration that was done without both sides receiving independent legal advice will not be enforceable in court.
A family arbitration agreement can be binding and enforceable in court if certain criteria are met.
For more information on these criteria and on arbitration generally, visit the Family Justice page of the Ministry of the Attorney General's website.
It is important to choose a lawyer you feel comfortable with. Here are some of the questions you should ask yourself when choosing a lawyer.
Is my lawyer someone I trust?
Does my lawyer understand issues that affect Aboriginal families?
Is my lawyer sensitive to safety and power imbalance issues?
Does my lawyer explain the options but let me make the choices?
Is my lawyer sensitive to the emotional and psychological tasks of separating?
Does my lawyer know that when children are involved, there is no such thing as winning?
Does my lawyer understand that bitterness and conflict can be more damaging to the children than the separation itself?
Is my lawyer willing to try negotiations where I don't have to be face-to-face with my ex-partner?
Does my lawyer believe that dealing with family disputes in the courtroom is a last resort? Only if we can't agree will we have the judge decide for us.
If you do not answer yes to all of these questions about your lawyer, consider changing lawyers.
If you and your partner cannot agree, or if there is abuse in the relationship, you may need to go to court and ask a judge to make a court order to deal with parenting decisions, child support, assets, debts, and property issues. But remember, you will have the least amount of control over the outcome with this option.
Going to court can be very expensive. For most families, paying lawyers to fight a long court case is extremely difficult. There are new expenses related to setting up two households, and many people struggle to give their children the same things they were able to provide when the family lived together. If you go to court, be prepared to have a judge tell you what they think would happen if your case were to go to trial. The court can also order one party to pay the other party's legal costs if he or she does things to deliberately drag things out or unnecessarily increase costs for the other side.
You may represent yourself in your court case, but a lawyer is in the best position to help you understand your rights and responsibilities and explain the court process to you. If you don't have a lawyer, you will need to work extra hard to be prepared and to be clear about what you want to say to the judge. Self-represented parties are subject to the laws and rules of court and cannot expect the judge or the other party's lawyer to give them advice. It is important to remember that even if a court process has been started, you can still try other dispute resolution options, like mediation, at any time during the court process.
If you chose to go to court, you should not expect to have an immediate court appearance. Each court appearance or conference with a judge must be scheduled. You may have to wait a number of weeks to get these appearances, depending on how many other cases are being heard at that particular court, unless your case is considered urgent. You will have to file your materials with the court within specific timelines in order to appear before a judge. Immediate decisions are only made in emergency situations. In most situations, a final decision will not be made on the same day that your case is heard by a judge, and you should be prepared to attend court for several appearances.
In Ontario, 3 courts deal with family law cases. The Ontario Court of Justice hears family law disputes, including custody, access, child and spousal support, adoption and child protection applications. The Ontario Court of Justice does not decide divorce or division of property matters. The Superior Court of Justice can decide family law disputes involving divorce, division of property, child and spousal support, and custody and access. The court does not hear adoption and child protection matters except on appeal. There are 17 Family Court of the Superior Court of Justice locations in Ontario. The Family Court hears all family law matters, including divorce, division of property, child and spousal support, custody and access, adoption, and child protection applications. In all other sites across the province, family law matters are divided between the Ontario Court of Justice and the Superior Court of Justice.
The family law rules tell you what steps to take and when, and which documents you need to give the other party and file with the court. The family law rules will give you information about timelines, where a case should be started and where it will be heard, how to serve documents, who are the parties, how to start a case, how to answer a case, financial statements, motions, conferences, evidence, costs, enforcement of orders. The Ministry of the Attorney General has prepared a guide to procedures to help you understand the rules as they apply in all 3 courts. The guide covers things to understand when going to court, including which forms must be completed, procedures when attending court, etc. The guide can be found on the Ministry of the Attorney General's website. You can obtain and fill in most of the court forms you will need online at the Ontario Court Forms website. In addition, the Ontario Court Forms Assistant, developed by the Ministry of the Attorney General, may be able to help. The Forms Assistant is an online tool to guide you through a number of the most commonly used family forms. It can also be found on the Ministry's website.
If your matter is not urgent, you will be given a first court date, which will be written on the front of your application. The first court date will be before a court clerk. Clerks will look at your file to make sure that both you and the other party have given each other all documents and materials and that all mandatory steps have been taken. First court dates provide you with the opportunity to resolve some or all of the issues in your case. You and the other party can speak with duty counsel or try mediation. If an agreement is reached, you can appear before a judge that day to ask for an order on consent, setting out exactly what has been agreed to. If you are unable to settle your disputes and your matter is not urgent, you will need to ask the clerk to schedule a case conference for your case to proceed.
The required steps in a family case provide you and the other party with opportunities to settle your family law disputes. These steps are called case conferences, settlement conferences, and trial management conferences. If it makes sense in a case, the conferences can be combined.
Regardless of the court where your court case was started, if you do not settle your disputes, you must schedule a case conference. At a case conference, you may explore the chances of settling the case, identify the issues in dispute and those that are not in dispute, explore ways to resolve the issues in dispute, ensure the disclosure of the relevant evidence, and set the date for the next step in the case.
To have an effective case conference, it is very important that both you and your former partner have all of your court forms completed and that you have provided them to the other party together with any other required documents, such as financial statements, before the case conference date. In addition to any other documents required in your case, you must prepare a case conference brief, provide it to your former partner, and file it with the court in advance of your case conference. Failing to file your brief or any other required document may require an additional case conference, which will extend the length of time to resolve your disputes as well as increase your costs.
At a settlement conference, the judge will focus on how the issues in dispute may be resolved and which issues may be settled without any further court attendances.
Trial management conferences are only required where a trial is required. These conferences ensure that you are ready to proceed with your case once a trial date is set. At a trial management conference, you and the other party must provide the judge with information about how you intend to present your case at trial, including the witnesses that you intend to bring and how long you think it will take for each of you to put your evidence before the judge.
If you have a family law matter that needs to have a decision made quickly, you can ask the court to make a temporary order by bringing a motion. The temporary order will stay in effect until the court has time to hear your case in full. The type of court orders that may be made on motion include custody, access, child support, spousal support, disclosure. Unless it is urgent, you may not bring a motion before a case conference. If you believe that your issue is urgent, you should talk to your lawyer or duty counsel right away.
In rare cases, the only way for the parties to resolve their disputes is to go to trial. A trial is the last step in a court proceeding. At a trial, a judge will make a final decision about all of the issues you and the other party have raised. It is the court process that leads to the making of a court order. The court order is a legal document that sets out the decision of a judge and is legally binding.
If you want to change a final court order dealing with any family law issue or an agreement relating to support, you can bring a motion without having to start a new application. Self-help guides are available on the ministry's website for parties who want to bring a motion to change or are responding to a motion to change.
To know love is to know peace. Love is strong affection for another, forming out of kinship or personal ties. Love is an attachment based upon devotion, admiration, tenderness, and kindness for all things around you. To love yourself is to live at peace with the Creator and in harmony with all creation. To know of the heart is to know the truth. Faithfully apply the teachings of our 7 grandfathers. Trust in the Creator. Be sincere in action, of character, and in utterance. Be faithful to fact and reality.
It is important to recognize that the journey of separation can be a long and very emotional one. But as you work your way through it, it is important to understand that with each step you will have begun the healing process. There are 5 important things we need for healing: safety, responsibility, respect, cooperation, and celebration. Safety is being free from physical, mental, spiritual, and emotional threat. A safe environment is needed for healing.
Experiencing fear is part of each individual's life experience, but living in constant fear of abuse or neglect is damaging to healing. Safety is an individual, family, and community responsibility.
Responsibility means you are in charge of your life choice and actions. You are willing to learn and change how you think about yourself and your behavior.
Responsibility means understanding that the wounds you received as a child at the hands of adults were not your fault. As an adult, you have to take charge of your own healing. Passing of these wounds onto others by blaming or hurting interferes with healing.
Respect is treating others and ourselves in a safe manner and accepting that each adult is responsible for their own choices.
Respect for an individual's choices of how to heal or how to protect themselves is important. Lack of respect for different views has sometimes divided families and communities.
Cooperation involves people coming together to accomplish goals of healing which are not possible for one person alone. Cooperation requires a balance of safety, respect, and responsibility.
Cooperation builds on communal strength to support healing through a balance or sharing of power in the family and community.
You should now be safely situated in your new home and have established a good parenting relationship with your former partner, and your children have adjusted well to the changes in their lives.
You can now reflect on the good aspects of your former relationship and embrace your life after separation. You should begin to feel good about yourself, and you should recognize that balance is once again achievable.
It is important to take the time to celebrate your survival. You have made it this far despite the things that happened to you.
It is also a time to celebrate and plan for your future. When you look back on your journey, recognize that it has made you stronger and healthier. It is now the time of rebirth.